theory of separation of power was given by Montesquieu. So it was given by Montesquieu. So theory of separation of power given by Montesquieu. That there is separation of power between legislative, executive and judiciary. They are separated in a watertight compartment. And there is no influence, that no one organ has influence over other organ. So work in a watertight compartment and no single institution has influence on the other institution. If we talk about the monarchy and dictatorship, power is concentrated in one authority and that authority cannot be questioned whether this order made by the authority is just or unjust. This is monarchy and dictators, power concentrated in one authority. But according to Montesquieu, there is a separation of power between legislative, executive and judiciary. They are separated in the watertight compartment. So watertight compartment, usually things divided for safety. So it is watertight compartment. तो शिप में सेफ्टी के लिए इस तरीके से वाटर टाइट कंपार्टमेंट बने होते हैं इस तरीके से. सो यहीं से बड़ा है वाटर टाइट कंपार्टमेंट, सेफ्टी के लिए बने होते हैं. And at the same time, there cannot be no dual membership. If you are a member of legislature, you cannot be a member of executive. And if you are a member of executive, you cannot be a member of judiciary. So there is no dual membership in the theory of separation of power. And USA was the first constitution based on the theory of separation of power, USA. So in USA, Article 1 talks about the Congress. So there is a division of the power. That there is two houses, House of Representative and Senate. Then all the executive power vested with the president. Then there is an independent judiciary in USA. So different articles deals with different organs of the government. So what is the problem in the watertight separation of power? Then there will be no checks and balance on other institutions. For example, legislature can increase its power, can increase its legislative power. Executive can stop implementing the law, it can implement its own made rules. And judiciary, it can charge its own territory, can define its own power. So if no organ can influence any other organ, means these organs are not kept under check. So if these institutions are not kept under check, so they will expand their power. An expansion of power by every institution will lead to the destruction of polity. It will lead to the destruction of the institutions. So lead to the destruction of polity in that respective country. Therefore, along with the separation of power, they come with the doctrine of checks and balances. So separation of power along with doctrine of checks and balances. For example, only legislature has power to make law, but if legislature make law that is unconstitutional, so it will be struck down by judiciary. For example, executive has to implement the policy. To implement the policy, executive need money, and no money can be spent except with the approval of the US Congress. Then if executive is charged under treason, that it can be impeached by legislature. So if executive charged under treason, legislature can remove the executive through the process of impeachment. For example, USA, President Trump brought the law that people from the 7 Muslim majority country will be banned. Judiciary struck down this as it was against a particular committee and it was violative of Constitution of USA. Then if judiciary try to breach its power, try to expand its power, the legislature has power to remove the judges. And even the judges of the Supreme Court is appointed by the president, subjected to ratification by the legislature. So appointment of judges, that is appointed by executive, ratified by legislature. So it is appointed by executive and ratified by the legislature. And as well as the removal of judges by the legislature. We ensure the powers. We keep a check and balance on the power of the judiciary. So through the process of the appointment and removal, legislature as well as executive keep a check on the judiciary. So in separation power, legislature has power to make laws, only executive has power to implement the law, only judiciary has power to provide justice to the people. But at the same time, provision has been made so that the check and balance can be ensured. And all these organs keep a checks and balance on each other by the theory of doctrine of checks and balances. So according to the theory of separation of power by Montesquieu, that legislative, executive and judiciary should be kept in a watertight compartment so that no organ can influence other organ. But USA implement separation of power along with doctrine of checks and balances, that each organ can influence each other and will keep a check and balance on the function of the other organ. Because if no checks and balance is kept on the power of these organs, they can become the monsters in themselves. So parliamentary democracy we talk about, so there is a prime minister and council of minister is a part of parliament. Although India, there is a legislature, parliament, executive, there is a president and prime minister, judiciary, that they provide justice to the people. So India, there is a separation of power where the legislature make laws, executive implements law and judiciary provide justice to the people. But in India, executive which implements the law is a part of the parliament, because in parliamentary democracy, prime minister and council of minister is a part of parliament. Minister, no one can minister until that person is a part of parliament. Therefore, there is no complete separation of power in the case of India. For example, Article 50 also talks about separation of executive from judiciary, but do not talk about the separation of executive from legislature. So, when Article 50 of the Constitution talks about separation of executive from judiciary, not separation of executive from legislature. Therefore, because India we follow parliamentary form of democracy, where there cannot be complete separation of legislature and judiciary. Therefore, Article 50 talks about separation of executive from judiciary. So, earlier district collector, which was created by the Warren Hastings. So, post of district collector was created by Warren Hastings. So, it was having two power. So, one of the most important function was collection of revenue, Other function was magisterial power, means providing justice to the people. But CRPC Act of 1973 took away the magisterial power from the district collector. So, there was a separation of power by the act of CRPC. The magisterial power from the district collector were taken, and the magisterial power of district judge were given to the district collector. Magisterial power were given to the district judge. So there is a separation of power. Otherwise, there is a theory of checks and balances. Then there is Article 50 talk about the separation of executive from judiciary, and this was implemented by CRPC 1973. That magisterial power district collector were taken and given to the district judge. So Article 50 talk about the separation of judiciary from executive. District collector क्या है? Executive. लेकिन क्या थी? magisterial power भी थी. क्या हुआ? सेपरेट कर दिया. judicial power किसको दे दी? district judge को. So the separation of executive and judicial power by the CRPC 1973. Then council of minister and prime minister has to prove the majority in the house if they have to remain in the house. This is how legislature ensure the accountability of the executive in parliamentary form of the government. So legislature captain executive. Legislature captain check on the executive through motions like no confidence motion, adjournment motion, question hours, 0 hour, debate, discussion, and various motion. Legislature keep a check on judiciary, on executive. Legislature keep a check on executive. So legislature keep a check on the executive, as well as legislature keep a check on judiciary by impeachment, by the process of impeachment. Appointment is done by the president with the approval of India. It is done on the basis of collegium system. That is appointment of the judges by executive and removal of the judges based on the removal of the judges by the executive, means by the president, on the basis of the resolution passed by the legislature. Judges are removed. This is how both legislature and executive keep a check on the judiciary through the process of removal, and appointment is done by executive only. Over a period of time, this theory of checks and balances in India has been weakened, because when the government in the parliament is in majority of the house, it can pass any bill without thorough debate and discussion and deliberation. Therefore, the theory of checks and balances has been weakened, especially when the government enjoy majority in the house. It can pass any bill. And one of the reason is anti-defection law, ADL, anti-defection law. The checks and balances weaken, especially when the government enjoy majority in the parliament. That is, bill passed without legislative scrutiny, without recommending it to the parliamentary committees. So, bill are not sent and discussion for the parliamentary committees. Parliamentary committee do not scrutinize the bill, and will pass without any legislative scrutiny. So, this is how check and balances weaken in the country, especially when the government enjoy the majority in the House. So if we talk about the judges, appointment and removal of the process of the judges is very difficult, that no judge has been removed so far. So in India, no judge has been removed so far, and judges are appointed by themselves. India is the only country where the judges are appointed by judges themselves. That is, in India, they are appointed through the help of collegium system, that is, one Chief Justice of India, other, and 4 senior most judges. Therefore, theory of checks and balances is not properly working in India. Supreme Court in Keshwananda Bharati case 1973 said the separation of power is a part of basic structure of constitution. So no government can snatch the separation of power. Like there will always be legislature, executive and judiciary, as it is a part of basic structure of the constitution, as said by Supreme Court in Keshwananda Bharati case of 1973.